green, you've got plenty of time. Once the light turns yellow, you're running out of time. And once the light turns red, you are out of time. And we ask that you please respect those time constraints. One thing that I want to caution everyone about is that these arguments are being live streamed. What that means is once you say it, it's out there. And it's out there for everybody to hear. So please think about what you say before you say it, because it's sort of like trying to put toothpaste back in the tube. It just won't work. Miss Angie, anything we need to take up before you call the first case?
No, Your Honor.
Let me introduce the panel before that case is called. We have Judge Arnold Golden from Memphis. We've got a special guest, Senior Judge Roy Morgan from Jackson, who's sitting with us today, which we certainly appreciate him indulging us in doing. And I'm Steve Stafford from Dyersburg. Ms. Angie, you may call the first case, please.
April Hawthorne versus Morgan & Morgan Nashville, PLLC et al.
Good morning, Your Honors.
Good morning.
Excuse me, good afternoon, Your Honors.
It is, isn't it? You know, I'm kind of lost in the process myself.
May it please the Court, my name is Catherine Bosky-Weiler, and I represent the defendants' appellants, the Morgan & Morgan defendants, in this appeal. At this time, I'd like to reserve 4 minutes of rebuttal time.
All right, you may proceed.
The trial court abused its discretion in this case, and that ruling should be reversed. It certified a class in this matter that has no business being certified. It failed to engage in the rigorous analysis required when considering a class certification petition, and it chose the easy way instead. It accepted plaintiff's argument that the court had already approved a class in the underlying case, the Galilee class, and that this legal malpractice claim implicated the same previously approved class. That argument is wrong. This is not Wofford. This is not the Galilee class. The class plaintiff proposes to certify here is not identical. There is not a singular issue that is being litigated as part of this legal malpractice case. These legal malpractice claims are different. They are complicated. And most importantly, they are not universal to the class. The certification order should be reversed. There are 3 fundamental and overlapping problems with the trial court's certification, all of which show an abuse of discretion. The first concerns the legal standard that the trial court used to evaluate the class certification petition. The second concerns whether Ms. Hawthorne has standing to represent the entire class. And the third concerns the proper application of Tennessee Rule of Civil Procedure 23.01 and Rule 23.02. I'll address each in turn. First, the trial court employed the wrong legal standard here, and that's evident from the trial court's order. The trial court decided based on the allegations in the pleadings itself, and that is not the appropriate standard to demonstrate rigorous analysis, to establish that the trial court carefully considered both the allegations and the evidentiary proofs in this case, and that is required by the law. A movement must affirmatively demonstrate compliance with Rule 23, not just pleadings. This court looks to federal law and its interpretation of Rule 23 in considering these issues, and federal courts have been very plain about this. Food Lion versus Dean Foods Company is the most straightforward. It's at 312 FRD 472, pinpoint site 482.
The court did have a hearing on this, didn't it?
It did, Your Honor.
It didn't just look at the complaint.
The court did hold a hearing. The hearing was on multiple issues. But the court specifically stated in its order that what it was looking at was not to anything that was argued during the hearing. It was looking to the allegations in the complaint specifically. And that's the problem. It's not that the court didn't conduct a hearing. It's not that the court did not allow the parties to brief the issues, for example. The problem is that the court did not look beyond just the allegations themselves. And that's what needed to happen here.
What was the effect of the court appointing CMM Settlement Solutions?
That is from the underlying Galilee action. And what the CMM appointment established was the scope of the class in the Galilee case. There is not a claim that the Galilee class is not a similar group or potentially the identical group of people that would have an interest in this legal malpractice action. The problem is not the class itself. The problem is with the claims. The claims are not identical, and they are not identical to every single member of the class. That's because the claims here are fundamentally distinct. This is a legal malpractice case. If you consider what the actual issues that the court would be considering
How are those claims different?
And that is exactly what I was about to say, Judge Stafford. Thank you. The Galilee case had one common central issue to the claims. Did the basic services of a funeral director and its staff include the supervision and the ensuring of the proper, lawful, and final disposition of remains? That was the Galilee class.
Well, in this class, wasn't there a fundamental issue as to whether or not counsel had consulted with the class representatives regarding settlement offers?
That's not the only allegation, Your Honor. The central question is whether the defendants deviated from the applicable standard of care in their settlement negotiations with each of the distinct, separate, at 11 funeral homes. We're talking about 11 because at that point in the litigation, which is immediately before and during trial, there were 11 remaining defendants. It's not the original number, but that's the number for purposes of this discussion and for the allegations in the complaint. The allegation in this legal malpractice case is, were those settlement negotiations handled appropriately? Was there a deviation from the standard of care in those? Those have to be evaluated on a case-by-case basis by funeral home. And the reason for that is because those funeral homes were all separate and distinct in their interests in this litigation. They all had separate concerns. It was a multifactorial analysis, as the court knows in any settlement negotiation. First and foremost, the court needs to understand there was never a universal settlement offer put on the table by those funeral homes. They were negotiated home by home by home. And that is crucial to understanding why, with that in mind, it's a multifactorial analysis that goes into negotiating settlements with each of those entities.
Where did the settlement offer come from that was not taken up with counsel?
First, Your Honor, we dispute that there was one that was not taken up with counsel, but setting that aside,
the class representatives was not taken to the clients.
And that's what we dispute. Forgive me, Your Honor, to be clear, that's what is disputed. It's not a single settlement offer, and that's the allegations in the complaint don't suggest that it was a single settlement offer.
Was any settlement offer taken to the clients?
There were, the allegations in the complaint are not clear about that. It certainly appears from the record that they were, and not only that they were, at least they were certainly discussed among all of plaintiffs' counsel, class plaintiffs' counsel in the underlying litigation. And the reason I have to clarify class plaintiffs' counsel in the underlying litigation is because some of those attorneys are still involved as class counsel in the Hawthorne case. That is also fundamental to the court's understanding of why these are actually different claims.
Hold on just a second. Let me make sure I'm understanding what you're saying. In the underlying litigation itself, the allegation is, as I understand it, that each funeral home that is involved in this would make a cumulative offer, settlement offer, an amount of money, correct?
For that individual funeral home.
Right. It'd be a total amount of money.
It would, yes, and then it was divided.
To settle all claims
yes.
against that funeral home.
That's another fundamental distinction for the claims related to that particular funeral home. So again, this is not a class-wide claim. It's not for the entirety of the class. Each of the individual members of the class were acting as if this were like a mass tort case that was combined into a class action. So each group of defendants, each group of plaintiffs with claims against that particular funeral home were proceeding, the negotiations with that funeral home were proceeding accordingly. So
let me say it this way then.
Yes.
Funeral home A offers to settle all the claims against funeral home A for X number of dollars.
Yes.
And it goes into the pot.
The last piece of that was not necessarily decided.
Okay.
Everything the court said as a predicate, yes, that's correct,
But it
Judge.
was payable upon settlement.
It was, that's correct. And there had been no determination at the time that these negotiations were happening of how those payments were going to be made. In fact, as it is suggested from the papers, I can't speak to what the witnesses would testify about now, but the understanding from the papers is there was no expectation other than that those settlement payments would be paid to the individuals who had claims against that particular funeral home. So, for example,
Where did I read, though, that the money was to be paid into a fund, and then the fund was to be divided among who all the claimants are?
Divided
Was that
equally.
not part of what the agreement was?
not at the time of the settlement negotiations. You're correct, Your Honor, in your understanding of how the settlements were dispersed after the trial. But that was a determination made post-trial, and that is not the time period we are talking about in this case. That's not when the alleged malpractice occurred. It's not even that phase where the trial court determined that the settlement fund would be paid into a single fund and distributed equally among all class members. That was decided even after the defendants in this case were no longer active in this litigation. It was decided post-trial. And the distinction here is the settlement negotiations that were ongoing were being undertaken with the understanding that these particular individual claimants would be paid based on their relationship with that particular funeral home. All of those negotiations were being undertaken simultaneously, but not collectively. That was not happening as a collective negotiation. It was happening on a funeral home by funeral home basis. And that's what I was...
Why would that be important at
Because-
this juncture?
Exactly. That's my next point, Your Honor, because there were many questions about the financial ability of these different funeral homes to make those payments. First, it had to do with the condition of the actual existing condition of the funeral home, but then beyond that, there were significant and ongoing issues related to insurance coverage, and the ability of different funeral homes to pay in to any sort of a settlement depended on coverage. It wasn't just the amount of coverage, although certainly that was an issue. It wasn't even just the existence of coverage. That too was an issue. There were declaratory judgment actions pending that were not decided until after the trial, after the alleged malpractice in this case. There were even questions about whether certain funeral homes had insurance at all, or whether funeral homes' policies applied for different periods of time relevant to the claims. All of
Why is that important?
Because there is no way to negotiate a settlement with an entity unless there are considerations specific to that entity's ability to settle. I
Well,
see that.
If the entity represents, I can pay this money, and the court accepts that, what difference does it make?
The plaintiff's counsel can accept that, but may I finish, Your Honor? I see that my time is up. Plaintiff's counsel can accept that. Plaintiff's counsel can make that recommendation to the client, but that happens on a case-by-case basis, and there is nothing in the record that states that that happened in the same way for the same amount of money for every single individual funeral home that was existing in this case. That's the problem. They were all handled separately and independently, and that's why a legal
Let me ask you
malpractice
one
came.
more question, and then these other gentlemen may have something, but was this argument made to the trial court
Yes, Your Honor.
at the certification?
Yes, Your Honor.
Okay.
If there are no more questions?
When you
Yes,
say it's a post-verdict administrative decision,
Yes.
and ultimately it was all put in a common pot, and everybody just shared the same amount, evenly dispersed,
Yes.
and they can do that.
They can. That's correct. But, Your Honor, that's a question of damages. This issue is about liability, and liability cannot be determined that way. That's the problem.
And it's your argument at that point in time, you didn't know that that would occur, you didn't have to discuss the likelihood that that could occur
That's-
with your clients at all?
I can't speak to that last point, Your Honor, but there was no understanding that that would occur. The court had not made that ruling. That was not the consideration as part of the, again, multifactorial analysis related to these settlement negotiations.
But you still knew it would be a possibility.
Certainly, Your Honor, but that does not affect the ability of these separate funeral homes to pay. If there are no further questions, I will
Thank you.
retain the rest of my time for rebuttal. Thank you, Your Honors.
Thank you. We will hear from the appellee.
May it it please the court, my name is Frank Watson of the Shelby County Bar. I'm one of the 3 lawyers that was appointed as class counsel. My 2 other colleagues, Tim Edwards and William Rout, had other commitments today, so I drew the short straw, so to speak. But let me first address, just very briefly, the procedural history on this case. The case was filed in 2019. Morgan & Morgan defendants filed a motion to stay, saying the case was pending on.
You're talking about the malpractice?
Yes,
case.
this malpractice case was.
Not the underlying?
That's correct. And I'll point out when I'm talking about that, Your Honor. They moved to stay, because the other underlying Galilee class had not been fully settled or resolved. We conceded on that, and essentially by November 2020, all the cases were settled. Then Morgan & Morgan files a motion to disqualify. Chancellor Kyle says he's a witness. We say these are settlement offers he's not privy to. He's not a witness. He denied that. It came up to an appeal. Your Honors denied that. They appealed to the Supreme Court. They affirmed, Your Honor. We came back down. Then they moved to transfer the case to circuit court. The court denied that. And then on the eve of class certification, they filed an amended complaint, or excuse me, an answer that alleged comparative fault on a number of non-class lawyers who did not represent the class. And they also put a comparative fault on Chancellor Kyle and said that he was at fault for approving woefully inadequate settlement offers. And so ultimately the court dismissed that claim, and we came back to the Court of Appeals, and the court said very clearly in its ruling that, in reversing the trial court's dismissal of the underlying allegations, said that Ms. Hawthorne clearly had a right to bring this claim, had alleged that properly, not only just for legal malpractice and breach of fiduciary duty, but also for punitive damages, that we met that high standard as far as the recklessness. And so that's where we are. The court reversed, we came back down. They complained that there's nothing in the record. Well, Your Honor, there's an affidavit declaration from 5 separate non-class lawyers that testify under oath that indeed settlement offers were made, and that the lead class counsel, Ms. Barnett, did not disclose those to the lead class representatives. They had no opportunity to say, well, Lee, I think that might be something we ought to take and present that to the court. That is under oath, and that's what they testified to. That's in our actual pleadings. So the court didn't just rely upon allegations in our complaint, even though Judge McCullough, in a class action that my firm handled called Howard versus Wilkes McHugh, says I can do that. The court can do that. But that's not nearly simply the Galilee class action was certified, so voila, we have another class action. But the court, while our brief is, I think, very well done, the court doesn't really look any further than the actual order. The order addresses every one of their arguments. Chancellor called it an extremely rigorous analysis under Rule 23.01 and 2. And I would remind the court that the standard of review here is abuse of discretion. So what that means, and this court says that in the Wofford published opinion, Wofford versus M.J. Edwards funeral, that indeed, if reasonable legal minds can differ on the appropriateness of class certification, you don't disturb the court's decision. Now, what they're really complaining about, Your Honor, is the fact that that Galilee class action was certified. That class action was not, there were 17 different funeral homes that were involved. There was not 17 separate lawsuits or 17 separate subclasses. There was one big class of people that are suing all of those funeral homes. And in fact, the funeral homes, when they appealed the class certification decision in the Galilee case, argued, don't lump me in with these other defendants. That's not proper. The trial court said it was proper. This court said it was proper. Now, let's talk about standing for a second. Ms. Hawthorne was only represented, she didn't have any other lawyer. She was only represented by the class counsel. She was in the class. The claim administrator has identified, and I want to clarify, our class definition is identical to Galilee with one exception. It's for people that made a successful claim, proved that they were a member of the class, and they were entitled to proceeds.
Well, who is the member of the class now, or who are the members?
The CMM, the settlement administrator, has identified, that's in the record, identified those people because that company paid out claims that were valid. So we know to the identity of everyone who was in that class.
Well, what number are we talking
I
about?
think we're looking at about 700 different decedents that families made claims either by way of contract or by
Members of this class?
Yes, that's correct. Now, so this class, those people, our argument is, and in the allegations and the proof that we have in the record so far, is that they were denied very valid settlement offers, that they didn't receive those, they weren't told about them. And, you know, I know this is hindsight, but this court has ruled in the Mathis versus NJ Funeral Home case that there is no statutory or common law duty to make sure that someone is properly buried by a funeral director. The case hinged on that. So when they say, well, we should have appealed and never settled these cases at lower values, if we'd appealed, the court would have ruled just what it ruled. There's no statutory or common law duty to ensure proper burial. Take them to the cemetery and you can leave. And that was why the whole case hinged on that allegation. So that's why these settlements, in part, were so important to the class representatives and to the class. Now, they complain, oh, well, if money was paid by M.J. Edwards, it only should go to those people that went to that funeral home. That's not the class they certified. That's not the class they asked for. And by the way, there were 3 funeral homes that settled prior to trial. They were the actual fairness hearing on that didn't occur until after the trial. But in that case, the court said, here's how we're going to divvy this up, because this is, as the court said, everybody's in this class, no matter where you went to the funeral homes, we're going to share and share alike in that. That's the fancy term of that is impari passu, which is a fancy Latin term that says without preference. The court did that, and Morgan & Morgan knew that. Why? They took $1 million legal fee from those 3 settlements, $1 million legal fee. They didn't come down to court and say, wait a minute, don't let one defendant pay anybody other than the people that went to that funeral home. They knew that this was impari passu. They knew that's how that was. And of course, keep in mind, that's res judicata for this class. No class member ever objected and said, gee, if I went to M.J. Edwards, who paid more money than this other funeral home, I should get all of that in my separate class. No one said that. So we are now bound by that. So those people all have damages to the extent that there were settlement offers that should have been taken and presented to those particular class representatives and submitted to the court. So that's really where we are. The order spells all of that out very articulately. So that's really all I have to say, Your Honor, other than that, you know, we need to move this case forward. It's been around for quite a while. And it needs to either try to get settled. But, you know, Ms. Hawthorne is clearly an adequate class representative because she was a class member. She did not have any other lawyer, and she asked, you know, about why are these settlements so low. We did our Rule 11 investigation. Part of their complaint, too, is, well, you didn't sue other lawyers. Well, the court addresses that. You can't sue someone that you don't have an attorney-client relationship with. And but even if you could, our Rule 11 analysis is, well, who committed malpractice? You're going to stand class action law on its head to say, well, the plaintiff and their counsel aren't good because they didn't sue enough people. Well, the counsel makes that decision along with the client. But if somebody else wanted to go file a lawsuit, they could have done that. I'll say this: the statute of limitations is run for any non-class lawyer. But as the court points out, only class counsel has a fiduciary relationship with the class.
What's the difference between the members of this class and the members of the Galilee class?
The only difference is that you, in the claims process, you had to say, okay, yes, I had a contract. You had to fill out a form and say, here's my contract, or here, I took this loved one. And if you got paid on that, you were a member of the class and you got settlement payments. So that's the only difference, but otherwise it's identical.
So, I mean, and this is in effect in the same class that the defendant wanted to be class counsel on.
That's correct.
And now is arguing that there's no class.
Right.
Is there any distinction between the final Galilee class and the proposed class here?
The only distinction is what I just mentioned, Your Honor, that,
Well, I mean,
and I don't know that that's where there is any
Didn't have
really.
a claim, wouldn't be part of the class anyway.
That's correct. There were some people that said, hey, I'm part of that class, and I want to make a claim, but then they went, the claim administrator had to spend a lot of time. In fact, there was even a special master involved to ferret through, were you really a member of this class? That's correct.
So the
And-
claims administrator in the first class determined the membership of the class.
Right, and they had an opportunity, if they didn't like that decision, to come to court and to say, he's wrong, or the company is wrong, I did go. So that went on for quite a while. The payments didn't happen just immediately. So that there was
Has the claims administrator undergone the same process here?
Well, yes, sir. All he did is he said, okay, here are all of the class members who we have paid. And that's in the record. That's part of our motion for class certification. His declaration sets forth, the number, and he doesn't set forth all the identity. It's clearly beyond numerous. And let me talk about, if you could try the case to a jury, and you could ask them to award whether there's liability for all 14 funeral homes that went to, which they did. The jury voted for them, which is part of the record. They checked yes, liability. They put percentage of fault at 1%, 99% on the cemetery, because they're the ones that lost the bodies. And then they awarded damages, not a separate damage for one funeral home and a separate damage, but a dollar figure per body. Now they're saying, well, a jury can make that decision, but here we can't, it's too individualized. A jury can't make a decision on whether or not 14 funeral home settlement offers should have been accepted. Well, that just defies logic. We had 14 funeral homes. Allegedly, they say with now all varying facts, but the facts were the same. And so here, all we're talking about is 14 settlement offers. The liability was the same. The conduct was the same. It defies me to see how this can't be and shouldn't be a class action. Now, the last thing they say is, oh, well.
Well, let me take you back to something that I understood opposing counsel said, and that is, would the standard of care be different based upon the individual fact situations of the different funeral homes?
Well, no, because they tried the case on a liability and damages to the jury, irrespective, the funeral homes want.
I think what she meant was the standard of care as far as the malpractice action.
Well, the standard of care is the same. The liability was the same. The facts were the same. Now, whether or not someone had enough money to pay, but these were offers that they said, we can pay this amount. So we're looking.
There is no way that the facts of the individual settlement offers would vary as it relates to the standard of care.
I don't think so, Your Honor, not on this case, because here we're talking about were these funeral directors legally, did they violate and mishandle remains? I think the jury verdict pretty much says that the responsibility was really the cemetery. Because what had happened, people would go out to the cemetery and say, well, where's my loved one buried? We thought we had the service here, and their records were all messed up. And as a result, they didn't know. But basically, they settled these cases, the 3 cases, and then there were other settlements. It was paid out in pari passu. So, at best, you're talking about, 14 settlement offers. Were those reasonable, given the fact that liability is the same? Damages were the same. So here it's not 18, usually you'll have defendants say, well, there are multiple questions of fact as to each plaintiff. That's not true. We're talking about 14 settlement offers that came in that were not given. And did that reach the standard of care? They'll certainly say, no, it didn't. That's fine. We already have an expert. He's in the record that says if these allegations are true, then they breached the standard of care. That's in our record. We did that before. We didn't have to do that, but we did do that. But they also talk about numerosity. I do want to point this out because the court says in the Wofford case that only one plaintiff has to have standing. What it actually says is, quote, at least one named class representative must have standing for a class action to proceed. We do not need to consider whether all members of the class have standing, simply whether one plaintiff has standing. Our review of the record reflects that at least one named plaintiff representative either signed a contract with the defendant funeral home or was next of kin to the deceased. This is sufficient standing for class certification purposes. One of their complaints is, well, where are all the other people? Well, the answer is twofold. Number one, they don't know about these settlement offers. They weren't communicated to the class representatives. They weren't even told to anybody. So that's why they don't know. As an officer of the court, it's not on the record, there was a little press on this case when it got certified. Our office was flooded with people that said, we want to be part of that class. So while numerosity is a test of, is the class itself numerous that joinder is impracticable, which clearly that's the case here, it's not how many people decided to go file a lawsuit. That's my only point. If you have any other questions?
I have one, if I may. At the trial of the Galilee case, you know how important the verdict form is. The jury submitted a verdict form. When it got to the issue, if they found liability of damages, it just had a space for just one amount overall, no breakdown per funeral home.
Right.
That was the verdict form. That's the way it was argued and presented by both sides at the trial of the case.
That's correct. And therefore, the settlement offers aren't individualized. I mean, we got one damage award. Thank you, Your Honor.
Thank you.
Your Honors, the allegations and the claims in the Galilee class, there was one argument. And that's why there was only one line on the verdict form, because it was the same question. It was about the mishandling of human remains. That's not this case. This is a legal malpractice case that has to do with settlement negotiations that were ongoing behind the scenes with specific and individual funeral homes. On page C955 of the record.
What's not a common question as to whether or not counsel presented the settlement offers to the class?
Page C955.
What's the difference whether it was N.J. Edwards' offer or another funeral home's offer? As I understand it, none of those offers were ever presented to the class.
That's the allegation, Your Honor, but
I
that's...
understand it's the allegation, but what's uncommon about it? What makes one different than the other?
Because the standard of care applicable here, assuming that we can put on a defense, which we will certainly be doing in disputing those facts, the standard of care has to do with each of those negotiations. And that's why I'm pointing the court to page C955.
That's where I'm losing you. Because the standard of care, I don't see how the standard of care can be different. If in fact the allegations are and are proven, there was a settlement offer and the offer was not communicated, how can there be a different standard of care for different funeral homes in that situation? I'm like Judge Golden, I'm a little perplexed there.
Isn't that the issue?
No, that is not the only issue. That is not the only allegation. The allegations are the attorneys didn't share that information, didn't share information about the settlement offers, as well as not accepting them. The allegations of negligence are not exclusive to a failure to communicate. But even if they were, there needs to be a determination about whether or not there was, number one, a deviation from the standard of care, and number two, proximate cause. There's going to need to be a determination about whether there would have been a settlement as relates to that specific funeral home. That's why this is so different. This is not just about whether or not there was mishandling of remains.
Why do you have to have that if there is an agreement or if the facts show that there was an offer?
I'm sorry, Your Honor, I didn't hear.
Why do you have to have proximate cause as to that funeral home if the facts are that that funeral home made a settlement offer?
Because it's
That was not
possible.
communicated.
Because it's possible that had there been an offer communicated, it would not have been accepted. That is not uncommon in litigation. That's why it's not just a question of a deviation from the
Is that why
standard
you
of
have a
care.
trial?
And it would be determined at trial, but that trial is going to have to involve questions for each individual funeral home. It's going to be 11 separate analyses. And again, if I may.
Seems like the point is, though, that the fact that it couldn't have been rejected because the attorneys never communicated.
If there was an offer made, and that's why, Your Honor, I apologize. I keep coming back to page 955 of the record.
Wasn't there an offer? Are you denying?
No, that is not, I'm sorry, Your Honor.
You denying there was an offer made?
No, what I am saying is it is unclear from the record what offers were made, if they were made, in what context for each individual funeral home. That is not clear, and that's why there is an affidavit at page 955 of the record that explains there were different negotiations happening with different funeral homes, all 11 of them, and they were all analyzing different ability to make offers, to pay, and to whether those negotiations should be accepted. They were separately handled. This was not a single claim. This was not a single allegation that could be determined on a class-wide basis. There is not commonality, and beyond that, there is not adequacy of counsel. Those are the problems here. The trial court's order reflects this understanding that there would be damages shared in a certain amount, and therefore those damages were equal. That is not clear from the record. I see that my time has expired. I apologize to the court. If there are further questions, I'm happy to answer them. We ask that the court reverse.
Thank you. Thank you, counsel. We will take this matter under advisement, and we will attempt to get you an opinion at the earliest possible time. We're going to take a brief recess before we call the next case, but if the parties to the next case will move forward and be ready when we come back in, it'll be a very short recess.
All rise.